I think it is clear to believe in the power of ideas.
Fresh thinking to the Manhattan Institute.
Good evening. I'm Howard Husick, Vice President for Policy Research at the Manhattan Institute, and it's my privilege to welcome you to tonight's discussion, What the Obamacare Decision Means, an analysis of today's landmark Supreme Court ruling regarding what is formerly known as the Patient Protection and Affordable Care Act. Although the court stopped short of striking down some of the central features of the law, letting stand, for instance, the requirement that individuals purchase health insurance or pay a penalty, it did limit the law's reach in other ways and justified its rulings in ways that have great legal significance. Tonight, we will analyze that ruling, discuss its implications, both for the U.S. healthcare system and for the legal system. We have an outstanding panel made up of experts from both of those spheres, starting on my left with James Copland, who's the director for the Center for Legal Policy here at the Manhattan Institute. To his left, Erik Jaffe, a constitutional lawyer from Washington in his own private practice, who clerked for Justice Thomas and filed amicus briefs in the case that was decided today. To his left, Avik Roy, also a senior fellow at the Manhattan Institute and a founder of Roy Healthcare Research, columnist for Forbes magazine. And then to his left, Paul Howard, who is the director of our Center for Medical Progress and the editor of our website, Medical Progress Today. I'd like to split this into two sections, if I might, before we bring you, the audience, in, the legal portion and the healthcare policy and implementation of the law portion. And I'm now going to introduce myself. I'm going to go down to this right over here and run this in a slightly more informal way, if I might. I'd like to start with Jim and ask you the following to get things going. The temptation, I suppose, for those who were concerned about the implications of this law is to say, as I believe the New York Times headline had it, Obamacare upheld. What do you see as the subtleties behind that from a legal point of view? Does the upholding of the mandate simply say, okay, that's all we have to focus on, or are you focusing on more than that?
I'm focusing on more than that, and from a policy perspective, this is a bad law. It was a bad law when it was conceived. It was a bad law when it was passed. It was a bad law when it was signed. It's a bad law before this decision today. It's a bad law after this decision today. And my colleagues who work on health care can explain the idiosyncrasies of why that is. From a legal perspective, that's not what the court's asking. The court doesn't ask about the policy merits of the specific law in front of it, and the court took pains today to stress that. That doesn't mean, however, that the court is divorced from politics. The court has always been involved and sensitive to the political implications of its decisions, going back to Marbury v. Madison, before that to Hunter v. Martin's lessee and what have you. The court's learned its lesson through the years, and if we have a little more time, I'll talk about an arguable, at least conservative defense of the Roberts position here, invoking Edmund Burke and Frederick Hayek and John Marshall and Alex Bickle. In terms of the decision itself, forgetting the fact that this bad policy survives, the Chief Justice, while giving the left and the president and the proponents of this bill what they wanted on the merits of the claim, sketched out at least three significant conservative rules of law of constitutional jurisprudence that I think will serve the court well and will serve those worried about federalism and limited federal powers well in the future. The first being the interpretation of the Commerce Clause, where the court, a majority of the court rejected the administration's claim and the dominant claim in this case that the mandate to buy health insurance as an individual was an acceptable use under the Constitution of Congress's power to regulate commerce among the several states. Secondly, the necessary and proper clause of the Constitution was deemed insufficient to reach that outcome, and Erik, who actually briefed that issue, is more qualified than I to talk about it at length. And then thirdly, and I think most remarkably here, the court for the first time really limited the tax and spending clause of the Constitution by effectively stating that Congress could not hold states captive with the Medicare provision, the Medicaid provision, excuse me, and say that you're going to lose the entirety of all your Medicaid funding from the federal government if you don't do what we want in implementing this law. This was something that was left out there as an option in the transportation context in a 1987 case called South Dakota v. Dole, that being Liddy Dole, the Reagan Secretary of Treasury at the time, but it's Transportation Secretary, excuse me, at the time, but it was never expressly embraced. There was never a line that was drawn by the Supreme Court or the lower courts, and a lot of us watching this, including my colleague, MI visiting scholar Richard Epstein in the Wall Street Journal, said, well, if not now, then when? This was poo-pooed on the left. None of the lower courts embraced this theory, and yet the court embraced it and actually did draw a line. It's not clear where the line is, but it did draw a line saying now, and I think that's significant.
And what you mean by that is that you're referring to the fact that states cannot be penalized if they choose not to participate in the great expansion of Medicaid that is at the heart of the Obamacare law, right?
Unfortunately, that's not what the court said.
Okay.
Unfortunately, 4 out of the 4 dissenting justices, the Republican appointees other than John Roberts, took that posture and said, we're going to toss the entirety of this provision. But the court actually said, well, they can't do this. And 7 justices actually bought onto the concept they can't do this, including Democratic appointees, Elena Kagan, an Obama appointee, and Stephen Breyer, a Clinton appointee, said you can't hold all of Medicaid funding hostage in trying to do this Medicaid expansion and twist the state's arms that way. But in terms of remedy, all they said was, well, you can, though, under the existing precedent, I think this does follow from the South Dakota v. Dole decision probably, you can say, well, this new money that we're throwing out here, right, you won't get if you don't do what we want in this law. And so that's really what the remedy was. But you can't use the old money. But you can't use the old money, which is of course, yeah, which of course for Medicaid is an enormous chunk of state budgets. And so it does, at least in principle, give states the ability to opt out of this law. Whether they really will or not in the long run, it's debatable. But you could certainly see a few states taking that tack, at least initially.
And we'll talk about that with Avik and Paul, who are both focused on Medicaid. But Erik, so Jim is essentially saying, take some consolation, if you will, in the limitation on the Commerce Clause, the use of the Commerce Clause that's been embraced here. As someone who actually filed an amicus brief regarding the mandate, do you take that consolation?
I take a little bit of consolation in it, in the same way that I took a little bit of consolation in Lopez, which was only a little step forward that ultimately sort of died on the vine over the years.
Talk about what Lopez is for the
So Lopez was the guns near school zone case where they said guns near schools don't involve commerce, so you can't have a federal law prohibiting it. But mostly what Lopez really said is your findings were really weak. And so go back and make better findings, and maybe we'll think about it. Or at least make a finding that the guns that are near the schools at some point in their existence passed in commerce or across state lines, and then you can do what you want. It didn't amount to very much at a practical level, but it was at least a harbinger of some concern for the federalism aspects of the Commerce Clause and for the limitation of powers aspects of the Commerce Clause. And I view this in much the same way. It's a positive harbinger. Whether it plays out over the next half a dozen cases remains to be seen. There are plenty of opportunities to chicken out. And that we'll have to wait and see what happens in the next dozen cases. One of the things that I'm sort of mixed feelings about is that while I agree with the Commerce Clause result, I agree with the necessary and proper clause result, and I sort of agree with...
Talk about what the necessary and proper clause...
So the necessary and proper, there were two aspects of arguments to uphold the individual mandate. One is that it regulated commerce because it controlled the way you chose to pay for future medical care, whether by self-insurance or by other insurance, and so that it was itself a direct regulation of commerce. The court rejected that, and I think rightly so. The other argument was that it was necessary and proper to effectuate a secondary regulation of commerce, the regulation of insurance companies, the requirement that they have that they don't have pre-existing condition limits and that they use community ratings. And they said the individual mandate is necessary to stop those two requirements from blowing up in everyone's faces. Right. And once again, I thought that was a bad argument. I thought the court rightly rejected it, or at least 5 members of the court. I guess it's hard to say whether it was the court as a court. But they did it for the wrong reasons in both instances. They did it for reasons that I'm not sure will ultimately play out well or coherently, or that they'll be able to defend in a reasonable way. So I'm pleased that they were moving in the right direction, because so much of Commerce Clause law is incoherent, and this is a step in the right direction. It's just not clear that it's a step towards coherency as opposed to a step towards better results that would result if you had a coherent policy. So at least it's coming to the right answer, but for at least reasons that I don't think are horribly defensible.
So you must have been somewhat surprised for the mandate to be upheld for reasons that the government wasn't arguing.
Oh, no. I thought the government certainly argued that it was a tax. There's no question they argued it was a tax. I didn't think it was a good argument. I was a little surprised by it. And I particularly thought the notion that it's not a tax for the injunction, but it is a tax for this was a bad ploy, but lo and behold, it worked. So I guess I'm wrong. And they're right, because it worked. Right? I had heard somebody else make a better justification. They could have written a better opinion that said, it's a tax for all purposes, but you waive the Anti-Injunction Act. That would have been coherent. I'm not, this is harder to swallow.
The Anti-Injunction Act requires that you can't challenge it until it takes effect.
Yes, that's right. So they said, no, you can challenge it now even though it's a tax in real life, because it's not a tax for the purposes of the Anti-Injunction Act. And, it all sort of hangs together by precedent. You can make a case for it. I'm not saying it's the craziest thing I've ever read, but it's just incredibly unsatisfying intellectually. And there were better ways to get there, I suspect. And so that sort of was my reaction to the entire majority.
Let me press you then. You said they've laid down a marker on the Commerce Clause on what you might be saying is the over-broad interpretation of the Commerce Clause. And can you give us, and they're going to have many opportunities to be tested on that. So give us some examples. Where could you see this potentially not requiring the eating of broccoli in the future?
Well, there are very few instances where Congress probably has the political clout to pass another mandate like this. I mean, I suppose you could imagine certain energy conservation things where they sort of force you to buy some energy conservation product that you wouldn't otherwise buy. But in many of those cases even, they could just say all light bulbs from now on have to be energy-conserving light bulbs. You can't sell a non-energy-conserving light bulb. They're not going to force you to buy it. You're just not going to have anything else in the market. So they can get there a dozen other ways.
Hard to imagine that.
It has very, well, it has very little, I suspect the specifics of you can't force people into commerce will not be played out in a dozen laws getting struck down, because those laws are not terribly likely to be passed. What's more important, I think, is that it speaks to a limitation on how much of a penumbra the Commerce Clause is going to get, and hopefully to some paring back of the notion of how indirect the effects on commerce need to be. Can the effects be something where, where it's closer to the inaction-action line, maybe they'll lean a little bit more towards saying that looks more like inaction, even if there's a good argument the other way. It's hard to say.
The principle appeals more to you than potential applications that you can imagine.
I don't see a lot of significant applications other than, at some point the government can get ridiculous and decide they're going to sort of get a command economy and control our lives. And I'm not discounting that possibility over the 50-year or 100-year period. It's just hard to see it today.
Okay. I'm going to get to the healthcare aspects of it, but I do want to keep on the legal part just for a moment. and to think about this in terms of the court, Jim. And you alluded to that. There's going to be a lot of discussion about the legacy of John Roberts, what this means. He sided with a lot of different sides in this opinion, and I'd love to hear you reflect on that.
He did, and when he was first nominated, I sort of said, you know, this pick makes sense for a Chief Justice who often is playing politics within the court. The Chief Justice has the ability to assign opinions and to some degree control the discussion and conference, and he sort of was groomed by the prior Chief Justice, William Rehnquist. This dates back. I mean, what this reminds me of a little bit, and time will tell whether the Chief Justice's gambit here works. But it reminds me a little bit of what John Marshall, the great Chief Justice, not the first Chief Justice, but the great Chief Justice at the beginning of the country did in the seminal case involving judicial review, Marbury v. Madison. This was the case where the Federalists, who'd been in charge under Washington and Adams, had been in power. Then they lost the election to the Jeffersonians, to the Democrat-Republicans in 1800, and passed the 1801 lame duck Judiciary Act, putting a bunch of Federalists on the federal bench to try to keep hold of power because they'd lost the presidency and the Congress. And in those days, you had to sort of take horses out to issue the mandates and deliver them by hand to all the judges before it was an official appointment. And they didn't all get out before it flipped over to Jefferson. And that was what was at issue in Marbury v. Madison. And Chief Justice Chief Justice Marshall was really worried about, well, what happens if I say, Jefferson, you've got to give these mandates out because the president, the newly elected president, was refusing to put the mandates out to these new judges. What happens if I do it and he says no? And so what he did was say, oh, well, you don't have to do it because it's unconstitutional, and we have the power of judicial review. And that was the case in 1803 that really established the principle of judicial review. We've seen this time and again through the court's history, and I think Roberts was influenced by some of the backlash against Citizens United, which I think is largely unfair, some of the more significant and more publicly understood backlash against Bush v. Gore, and I think back in his mind, the showdown between the Supreme Court and the Roosevelt administration in the 30s, 1937 being the last time we saw the Supreme Court overturn a major piece of congressional economic legislation during the New Deal and creating the court packing scandal with the Roosevelt administration. I think Roberts was very conscious of this, and I think was very consciously, and perhaps late in the game, given the writings of the opinions, trying to develop different majorities on the court, pulling a couple of Democrat appointees in on one of the provisions, siding with the liberals on the definitive holding on the mandate, but with the conservatives on the rule under the Commerce Clause, and really trying to fashion an opinion here that maintained the institutional integrity of the court, but set out some conservative principles and some boundaries and some guidelines of law that if the court gets a couple more like-minded people on it in the next several years or the next decade or two, the court can use this as a stepping stone to clawing back gradually and slowly against the sort of sweeping interpretation of federal power that basically has been the law since 1937, at least for economic regulation. This is the sort of gradualist approach that Burke and Hayek and Alex Bickel, a conservative sort of constitutional legal scholar, have embraced. And so I don't think it's implausible. Whether it works or not, of course, is an open question.
So you buy that, Eric? This is John Roberts' Statecraft, and he's defending the legitimacy of the court in ways that will set the table for important decisions to come.
I want to buy it. I really do. I'm attracted to it as a theory, and I even am slightly persuaded. There's something in me that says at the end of the day, he's also a creature of the executive branch for a very long time, and many conservatives still believe in significant federal power, and at the end of the day, it's the libertarians on the court and some of the states' rights folks that want to pare some of that back, but I'm not sure it's all conservatives, and he may be a conservative of that stripe who does care about the Constitution but is not going to unwind the last 100 years and pare the federal government back. So I'm torn between those two inclinations on what's going on here. I think it is certainly true that John Roberts has shown he's willing to overrule bad precedents when the time is right and they're particularly horrible. Here he has shown he's willing to take what is a reasonably good step in terms of staking ground on the Commerce Clause, even though it had no impact on the case ultimately. And so your theory, I think, like I said, it's very attractive, and it might even be right. It's too soon to tell. And he holds his cards well to his chest, at least so far. I think he's a smart guy. I think he is playing the long game. I just wish I knew what his end game was. I know he's playing a long game. I just don't know which long game.
Okay. All right, now let's turn to the effects of this law itself, because this law is now upheld, right? Justice Kennedy said strike down the whole law. That didn't happen. It's going to be affecting 17% of the American economy or more. I don't know how you count this. But there was an important part of the decision that limited potentially limited the expansion of Medicaid. You've written very critically of the health effects of Medicaid program. Does this give you some reason to cheer?
Well, my advice to the audience, excuse me, Howard, my advice to the audience in terms of the policy implications of this law is to start drinking.
Before it's banned, is that it?
Only soda pop is banned. I think Scotch is still legal. I'd like to start actually by quoting one knowledgeable commentator who, in advance of today's ruling, said this about the idea that the individual mandate was a tax. The individual mandate is absolutely not a tax increase. You can't just make up that language and decide that's called a tax increase. That was President Obama in 2009 in an interview with George Stephanopoulos. There's two important things to understand about today's decision in terms of the policy aspect, how it's going to affect healthcare in this country, how it's going to affect your healthcare in this country. The first is obviously the individual mandate, and the second is what Howard alluded to, which is what the Supreme Court decided about Medicaid. Let's start with actually the individual mandate. So the reason why the individual mandate is part of Obamacare is for a simple reason. The law tries to subsidize insurance for some people. By doing so, it makes insurance more expensive for people who are healthier and younger. It subsidizes insurance for the older and the sick, people with so-called pre-existing conditions. But by doing so, there's no such thing as a free lunch. The only way you can make insurance cheaper for those people is by making it more expensive for people who are younger and healthier. So today, in states like New York, where this kind of policy already existed prior to Obamacare, insurance is incredibly expensive for young people. So the average 19-year-old probably spends, on average, maybe $500 a year on health care, if that. But the law, Obamacare and the New York State law, prior law, requires that individual to spend several $1,000s a year to buy health insurance, so that someone who's, say, 62 can have slightly less expensive health insurance. That dynamic, of course, creates a system where young people say, you know what, why should I spend several $1,000s a year on health insurance when I may be making $25,000, $30,000 a year? I have better ways to spend my money on pizza and beer, perhaps, or video games or whatever, but people aren't going to spend $3,000 a year if they're 19 years old on health care. So they drop out of the system. They don't buy health insurance. As a result, the only people who actually buy health insurance are the older and sicker people who really need it. And as a result, because their average health expenditures are so high, the cost of insurance actually goes up. This is what health policy wonks call the adverse selection death spiral, which is basically a way of saying it destroys the private insurance market. So the whole reason why Obamacare included an individual mandate is to force these younger and healthy people to buy health insurance, effectively to cross-subsidize, or to their wealth or what a lack of it is being redistributed to the older and sicker people who are going to enjoy slightly less expensive health insurance because of this law. So for the average 19-year-old or 24-year-old, they're going to pay basically double or triple what it would normally cost them to have health insurance, so that a 55-year-old might pay 10% less. That's why the individual mandate's in the law, because otherwise the private insurance market would blow up. But what the Supreme Court pointed out, or at least Chief Justice Roberts in his opinion, his very creative opinion I might add, is that the individual mandate contained in Obamacare is weak. It's the maximum fine is $695 or 2% of your adjusted gross income, which for a young person is a lot less than what they'd be forced to pay for health insurance. And now, if you're 19 years old and you get into a drunk driving accident, you can get health insurance the next day, and it's no problem because your insurers are forced to provide that insurance to you because you now have a pre-existing condition. So what young person is going to pay for health insurance that costs him $3,000 a year when he can instead pay a tax, not a fine, and instead get cheap insurance later? So the point I'm trying to make is that despite the fact that there is this tax, penalty, requirement, whatever you want to call it, it's actually a weak tax, a weak penalty. It's not the IRS collects the money, but they can only collect it from your tax refund. So if you have no tax liability, they can't assess the mandate. They can't actually issue a lien against your existing income. That's actually specified in the law. So the only way that the IRS can actually collect the fine, penalty, tax, whatever you want to call it, is if you actually have a tax return and they just take $695 out of your tax return.
Well, Avik, let me just jump in at that point. So doesn't the combination of the fact that there is a relatively weak penalty, if we can call it that using common speech, right, and the fact that states are somewhat less incentivized to include a lot more people in the Medicaid program, which was the big bump that Obamacare was, doesn't this really mean that this is no longer a universal health insurance law?
Well, this is, I think, one of the interesting things that I've written a lot about that I think, again, because we've been focused on the constitutional element, we haven't focused as much on the policy element, and that's kind of the point I'm getting to, Howard, is that this mandate is weak. And because the mandate is weak, a lot of young and healthy people are still going to be incentivized to stay out of the system, to stay uninsured. And what that's going to do is it's going to drive up the cost of health insurance dramatically, because Obamacare forces all insurers to do things in terms of what they cover, in terms of the way the plans are financially structured, that makes those plans much more expensive. Imagine if you were required to go to restaurants to eat all your food instead of being able to cook at home. Would that make your food expenditures go down or up? If you went to a restaurant and you were forced, and every restaurant was forced to serve organic vegetables, we may all think it's great that organic vegetables are on the menu. I love to go to the Union Square Green Market myself, but it makes restaurant food more expensive, right? And we'd see that at the end of the day. And that's what's going to happen to health insurance. Health insurance is being larded up with a lot of things that the government decides that you need in your health insurance plans. And these health insurance plans are going to be much more costly than what you could buy, say, if you had a health savings account, catastrophic plan, and some of the things that I think a lot of us free market types would prefer. The point of all this is that the weak mandate, combined with all the regulatory architecture of Obamacare that's now preserved intact, will massively drive up the cost of insurance, especially for younger and healthier people, but also for older and sicker people, because those younger and healthy people are going to drop out of the system, mandate or not. The second point I'll touch on briefly and then pass it on to Howard, or to Paul, is this issue of the Medicaid rollback, partial rollback, where very importantly, the Supreme Court stated that states could opt out of the Medicaid expansion because the Medicaid expansion was seen as coercive toward the states. Well, this is interesting for a number of reasons, but most importantly because it may have a significant impact on the budget deficit. There are two principal ways in which Obamacare expands coverage for the uninsured. One is by expanding Medicaid. Expands Medicaid to cover another 17 to 20 million people, depending on whose projections you believe.
17 to 20 million into Medicaid.
17 to 20 million. On top of that, there are these subsidized exchanges that every state is supposed to set up that will provide government-approved private insurance, which will be of a higher quality than Medicaid, to the point that Howard was alluding to earlier. Medicaid is actually really terrible insurance that in many cases has worse health outcomes than people who have no insurance at all, because it pays doctors so little that many doctors don't take Medicaid. So if you broke your arm or you have an asthma attack and you're on Medicaid, you can't find a doctor who will see you because the Medicaid program doesn't pay the doctor enough to see you. So, but the point here is that states now have the ability, because of these technical elements of the way the Medicaid expansion and the exchange, this new entitlement with the exchanges overlap. States like New York, which have very generous Medicaid programs, can pare back their Medicaid programs because they pay some of the costs for that. And instead, let those people go on the exchanges, which are completely federally funded and at a much higher level per capita, per person, than the Medicaid plan. Every state that is in the New York type situation, New Jersey, Connecticut, are both also in that situation. A number of major, large wealthy states are in this situation that have extensive Medicaid programs. They're going to do this. And that increased cost that comes from putting those people on the exchange versus putting them on Medicaid is going to increase the amount of spending dramatically in the law. And I know, actually, I talked to some people on Capitol Hill today. The Congressional Budget Office is crunching some numbers on that. I'm not sure if they're going to crunch the numbers the right way. What I've been told is that the CBO continues to assume that all states will participate in Obamacare as it was originally written. But I think we all know that that's very unlikely to happen. And that could add to the cost of the law on a, say, 10-year basis, another $200 billion.
Well, Paul, play that out for us a little bit. If, as Avik says, states no longer will lose their existing Medicaid funds, which are a huge part of their budgets, right? If they were going to lose their existing Medicaid funds, which the law would have permitted before today's decision, that would have blown a huge hole in this state or any other state's budget. But that's no longer going to happen. So play it out. If states do decide we're not going to play on adding a whole lot more people to Medicaid, and yet there's still interest in Congress, in part because of what Avik just said, it could blow a hole in the federal budget. Play that scenario out for us. What happens next?
Well, it's going to be an incredibly interesting scenario. And I think that, to borrow a turn of phrase from an earlier court case, the Medicaid ruling here is the hanging chad of this case. Because Avik's absolutely right. So at least some people under the law, at least from my reading, say for instance you're a legal immigrant and you make a little more than 100%, 125% of federal poverty level, normally you would be eligible for Medicaid, but if there's no Medicaid available to you, you're also, as a legal immigrant, eligible for exchange subsidies on the exchange. The exchange subsidies on paper start at 100% of FPL. So there could be a population out there, and honestly I don't know what population it is, but there's at least some people who states would look at and say, you know what, we're happy to not have any Medicaid match for that population, and we're going to send those people to the exchange and get those subsidies and pass the costs on to the federal taxpayer. Medicaid, as we started talking about earlier, is the second largest item on most state budgets behind education. And states, red and blue alike, are tremendously concerned about Medicaid costs. They've approached CMS now, and in past years, New York State is one of them. I'm sorry, the Center for Medicare and Medicaid Services. They've approached the federal government. New York has approached the federal government and said, we want a very big waiver from you to radically change how we administer the program, and we're going to share that savings with you. In New York, the state is saying, we think we can save $17 billion over 5 years if you give us this waiver, and we'll give us 10, you can keep 7. So I think states would look at this as an opportunity to bring some leverage to the table with the federal government and say, what is our option here? We can send people to the exchanges, and it's going to be an extraordinarily expensive picture for federal taxpayers, or we can talk about you giving us much more flexibility for the Medicaid program, perhaps in some kind of block grant arrangement. Let us change coverage, let us change copays, let us experiment with different forms of coverage. I think that's going to be a little bit of a game of chicken, depending on how those cards play out. President Obama can obviously go to the populations in those states that are not getting Medicaid expansions and say, there's actually money literally in the exchanges for you if your states would just accept it and give you Medicaid coverage. Republicans can reply, it's terrible coverage. Like Avik said, you're not going to get good access to doctors. You're not going to get good coverage on Medicaid. You're much better off getting some kind of private insurance coverage. So depending on how the states, if enough of them actually do use the leverage that they've got and push hard enough as a group, I think they could get some change.
So we've gone from the issue that's really easy to understand, do you have to buy it or not, into public policy complication land is what I think we get out of your remarks there, but the stakes are very, very high.
Absolutely. I mean, like I said before, I think it's going to be a little bit of a game of chicken. I mean, if there is a number, depending on how the subsidies play out, if enough people are potentially eligible for the subsidies, the states could take that move that Avik is suggesting and saying, well, you know what, we're going to send those people into the exchanges. That creates a tremendous incentive for Congress to revisit that arrangement and try and get the cost down through some other mechanism.
Are those going to be the issues that emerge as this law takes effect? Every business with 50 or more employees has to either offer health insurance or start to pay a fine of $2,000 per employee, I believe. Is that going to be an issue that starts to get people's attention now that the law has been upheld? Avik, do you want to weigh in on that?
Yeah, actually, Howard, I'm glad you brought that up because that allows me to bring up a related point, which is that this is not the end of the constitutional challenges to Obamacare, actually. There are a number of other challenges, one of which is around just this point, the employer mandate. So it turns out that because of a drafting error in the law, as you know, it was kind of hastily put together, just a little bit, right? The states are under Obamacare. The states are supposed to be setting up these exchanges, the subsidized exchanges that for certain low-income populations that will provide subsidized private government-approved health insurance. The law states that if the states don't set up those exchanges, and many states, particularly those with Republican governments, have chosen not to set up exchanges because they've not wanted to implement Obamacare until the litigation, the election, et cetera, play out. The law specifies that if the state doesn't set up the exchange, the federal government, the Department of Health and Human Services, can come in and set up a federal exchange instead. And that's been kind of a threat that a lot of people thought would say, okay, well, even you conservative states, you'll set up your own exchanges because you don't want, Kathleen Sebelius doing it for you. But there's a problem, and that is that, again, because of this error in the law, it turns out that exchanges that are set up by the federal government aren't eligible for the subsidies. Only state-run exchanges get the subsidies. And again, that's just because of a drafting error in the law. And that's relevant to the employer mandate because the fines that employers face if they don't insure all of their workers only kick in if some of those workers collect subsidized insurance on the exchanges. So if you, say, are in, Utah, and you don't have a federally approved exchange or an Obamacare certified exchange, or, say, Alabama or Texas, let's take Texas. The federal government can come in and set up an exchange, but because subsidies can't be collected, participants in that exchange can't have subsidized insurance, the employer mandate doesn't work because the employer mandate only kicks in if people are collecting subsidies. Because the whole point of the employer mandate was to say we don't want employers to dump everyone onto the exchanges. Now, the Treasury Department, the IRS, in another example of creative lawmaking, basically decided that they were going to issue a regulation or an interpretation saying that federally run exchanges would qualify for subsidies, and so all these other regulations like the employer mandate would kick in. And a bunch of people are now readying a lawsuit on just this question. The IRS can't make up law. They have to actually go by what the law says. So that's one of the things that's being challenged that will come up, I think, once the dust settles on this current ruling.
Right, and of course, a lot of economists, like the Manhattan Institute's Diana Furchtgott-Roth has written that there could be employment effects. If you have 49 employees, you might not want to hire number 50 if it's going to cost you $2,000 per every one.
We see this in Europe quite a bit.
What you bring up, Avik, is implicitly this question of we're hearing House Majority Leader Eric Cantor has scheduled a vote the week of July 9th for the House to vote to repeal this whole law. And you've sketched the complications of the law that are going to be with us if it is not repealed. The mantra of Governor Romney is repeal and replace. What would repeal and replace? We know what repeal would mean. Is repeal, and I'm going to go to Erik as our Washington guy, is repeal imaginable as you read the situation in Congress and the potential Congress? And then what would replace actually look like? And I'm going to look to Avik and Paul for that.
Not being much of a political guy, I don't think repeal is imaginable prior to the election. It's inconceivable that Congress could get its act together to do something so dramatic on the eve of an election. I don't think they can do it in 2 years, much less in 6 months. But no, and take this from where it comes. I know absolutely nothing about politics other than what's in the air where I live. But I just don't see it because I have no faith in their ability to actually do something that efficient.
And would there need to be 60 Republican votes in the Senate to do it, as you understand it?
Well, I would assume that's right, that there would be a
Jim,
filibuster.
is that
I
how
assume
you see
that Obama would veto it.
No, I mean, even in a new administration.
I mean, I think under a new administration, assuming you had a majority or split Senate, the question then becomes to what degree you could bootstrap a reform through the budget process. And the Supreme Court may have green-lighted a potential avenue, and I'm not totally sure. I'm sure there are going to be a lot of constitutional scholars thinking about this. But they may have green-lighted a potential avenue by saying this is a tax rather than a regulation to potentially use the budget process, which of course doesn't have a filibuster rule. It would be sort of interesting and potentially poetic justice if sort of machinations in the congressional rules that were used to get this thing passed on a party line vote in the first place wound up being used in the inverse on a party line vote through interesting congressional machinations to get it repealed or revised in some fashion. I don't know about an outright repeal.
This tax.
But through the budget process, it's conceivable, I suppose, that you might be able to get around the filibuster rules to at least change parts of this law. But to what the actual scope would be there, I'm not sure.
And Paul and Avik, let me start with Paul. If replace is to now be demanded of those who are concerned about this law, what are the ways to talk about that in a way that will compete with your kids are on insurance, health insurance till 26, you get insurance no matter when, if you have a pre-existing condition. What is the form that replace can take that can be attractive to the American people, do you think?
Well, I think we need to sketch out a vision of health insurance where patients and families are actually in control of their health insurance. And I think the response to the arguments about being on your insurance till you're 26 is to say 17 million, as Avik pointed out, at least half of the coverage under the Affordable Care Act is going to be through a terrible program, Medicaid. We have a better option. That is to use the tax code either through a tax credit or a tax deduction or some mix of those two to give everyone truly portable insurance that they can take with them from job to job and not worry about losing. And you can give people incentives to keep and hold that insurance by saying you may, when you buy insurance, you might be risk rated once. So your employer would say when you're young and healthy, or I'm sorry, the insurer would say when you're young and healthy, if you buy insurance and you keep that insurance throughout your life, even if it has different companies, you don't have to worry about cancer or diabetes driving up the costs of coverage. And in a market where individuals are choosing among truly competing insurers, not in one market where the government is going to tell insurers all of the products and services that it has to cover, and the only difference is your copay or your premium, then you can really see providers and insurers competing to bring more quality to the system and bring true efficiency to the system. Right now in the system that we have, providers look to payers, that is insurance companies and Medicare and Medicaid, about what they want and not what about the patient want, because the people who are paying the bills are not the people who actually get the benefits when they go to that doctor or that hospital. I think sketching out that vision of personally owned portable insurance that protects you throughout life, that's in your control is really a winning formula.
And Avik, your vision of replace.
Yeah, actually, let me just jump back quickly to one thing that you were asking earlier on this issue of can the law be repealed via a simple majority in the Senate of 50 plus, say, the vice president. It can be. I've studied this issue actually quite closely, and if you're in the Senate and you're working on a provision that involves anything that's germane to the budget, then it can be passed via the reconciliation process, and that only requires 50 votes plus the vice president or 51 votes in the Senate. So if you can get 51 votes in the Senate, you can repeal it. You don't need 60 votes. You don't need a filibuster-proof majority to repeal the law. On this question of how do you replace, and I guess Paul and I should disclose that we are advisors to the Romney campaign on just this question. I'd say that Paul hit it on the head that the central theme in every aspect of healthcare is give individuals more control over their own health dollars. If there's one thing that is true of the American healthcare system that's really, really bad, it's that people don't control their own health dollars. If you're in the private employer-sponsored market, some HR official at your employer is deciding what your health insurance plan is. If you're on Medicaid, if you're on Medicare, the government's deciding. For the most part, with some exceptions. So that's the key. If you give people the choice of the insurance plan that they want, they'll naturally choose plans that are more cost efficient, that are better value. It's again, the analogy I like to give is it's the difference between a cash bar and an open bar. When you go to the cash bar, maybe you'll think about getting the house wine or the house beer or whatever, but if it's an open bar, you're going for the single malt scotch or the 2005 Bordeaux or whatever your tastes are. So, and healthcare is like that. Healthcare in America is like the open bar. It's not like the cash bar, and you can understand why it's getting increasingly expensive. And I think one thing that conservatives in general conservatives made a strategic mistake in 1993 and 1994 when Hillary Care went down. I think we sort of thought, well, the American healthcare system is great. We don't need to do anything about it, and the liberals will never dare try this again because they know they'll get killed at the election in the voting box. But actually, there are a lot of things wrong with our healthcare system. Healthcare is 1/2 of federal spending, and it's we spend more per capita on healthcare in terms of government spending than all but 2 other countries in the world, more than France, more than Britain, more than Germany, all these socialist utopias that we don't like to, we say unkind things about. We spend more on healthcare per person than they do as a government, let alone what we do with the private sector. So there's desperate need for reform, and I think it's really important that conservatives, particularly those who care about the size of government spending, the growth in government spending is entirely healthcare spending, and we've, as a community, have to invest a lot more intellectual capital into thinking about how to reform healthcare.
I'd like to bring you in now. Questions for any and all on the panel. Gene Epstein from Barron's is here. Wait for the microphone. Here it is, Gene.
Could we get back into the weeds a moment with some of the things you were saying, Avik? You said that somebody's 28, 27, thinks he's going to live forever, never had an unhealthy day, isn't too interested. So you said that he might pay taxes, but that the only way he can get, 2% of his income or $695 extracted from him is even if he pays taxes, he has to have an over-withholding? Is that one thing you said? And then the second related point is, are you saying that he will know that it's 2% or $695 or $3,000, and so to belong, and then he will also know that if he pays the $695 or the 2%, worst case, he'll get health insurance anyway because there's no penalty against pre-existing condition. So one would think that that's kind of a no-brainer that most people. Well, maybe I summarized it enough, but
I think you were paying attention.
Yeah. Oh, thanks.
I think you just passed you.
But my question is that did you say about tax refund? I mean, the IRS can say, hey, you owed $3,000 in taxes, but there's $695 due us, or 2% of your income due us, because you're not, then they could charge them for that. It's not a refund
They
issue,
can
right?
send you a stern letter saying you owe them $695, but they can't do the conventional thing they do with tax collection. They can't issue a lien on your bank account, things like that. They can't do anything else. They can't do the normal types of things that the IRS usually does if you don't pay taxes that you're
You can
owed.
just ignore their request for the money, so to speak.
Yeah, they can't do a criminal prosecution. They can't.
But they're very intimidating.
Yeah, it'll be a stern letter, kind of like the ones that Kofi Annan used to send to people.
Okay, let me get J.P. Donlin over here from Chief Executive Magazine.
Thank you, Howard. My question is for you, Avik Roy. Beyond the mandates, what are the other direct or indirect or unintended consequences of this? Given that a number of business leaders we've spoken with, and I've shared this with Howard, are of the view that if this law is upheld, and it seems to be, they're going to simply dump it on the exchanges, and a lot of companies are going to seek to exit their liability. So I would like you to expand further on how this will affect businesses, beyond the mandate. And when I say businesses, I don't mean the S&P 500. I mean, the average businesses that employ,
So could it be the end of employer-sponsored health care is what
exactly,
you're saying?
yeah.
An important point to note is that if you're a company that employs more than 100 people under a law called the ERISA law, you have the ability to self-insure your workforce, which basically means you take that pool of people who works for you, you tell an insurance company, basically do the paperwork and pay for their health care, and we'll pay you a little commission for that, and so they're what's called self-insured. So they don't really have conventional insurance. Effectively what the company is saying, we'll pay whatever the health expenditures are for that population, and pay the insurance company a middleman fee, effectively. So for a lot of large companies, if you work for a big bank, say, or you work for General Motors, you probably won't find much disruption, because those companies, while they do have an incentive to drop coverage because insurance keeps getting expensive, there's also a lot of economies of scale and other things, but they're kind of exempted from a lot of things related to Obamacare. The real impact is on smaller businesses with less than 100 employees, particularly less than 50 employees. Those are the businesses where there's going to be incredible incentive to not offer health insurance, because a lot of their employees might be able to get subsidized exchange, particularly, say, startup companies, which are typically employing younger people who aren't making that much money. Restaurants, say, those kinds of institutions will be more incentivized to even pay the mandate, because it's cheaper than sponsoring health insurance for those employees. The employer mandate has more teeth than the individual mandate, but still, it's a lot cheaper than paying for health insurance. So I think what you're going to see, and this is the point again we were talking about earlier, and again we see this. There was a great Wall Street Journal article about an editorial about Italy, and how in Italy, once you hit the threshold of 19 employees, this set of regulations comes in. When you hit the threshold of 30 employees, this set of regulations comes in. And that's how it's going to be with Obamacare. That once you hit that threshold of 50 employees, you're going to start another company. You're not going to hire the 50th employee. So you're going to see a lot of that kind of pressure on the entry-level labor force.
So economic distortion through the law. Yes, sir, right here in the second row. Wait for the microphone, please. Debbie, over here.
I want to pose a question to the two lawyers on the panel. And if I'm incorrect in my recollection of the facts, you please correct me. My understanding was that one of the reasons that Obama said this was not a tax was not only for political reasons, but also because he needed the extra votes in the Senate in order to get it. And yet the Supreme Court has decided on the basis of something that the Senate did not vote in favor of. And my question of you, is there ever been any precedent, I haven't read the opinion, of course, but is there any precedent where the Supreme Court has ignored what Congress has done and the reasons given for doing it and the basis in order to uphold the law?
Yes, lots of times. Every day, every other day. Justice Ginsburg cites the license tax cases, which I think could easily be characterized that way. I probably could go research a dozen more. What Congress called something, I mean, Chief Justice Roberts is not wrong when he says there's a bunch of case law out there that says it doesn't matter what you call it. It matters what it is. And that Congress slapped a name on it and called it a tax when it wasn't, doesn't matter. And that they called it a license fee when it's actually a tax also doesn't matter. That is indeed what the cases say. I don't like those cases. I think your point is right. And it's in fact what disturbs me about the way it ended up getting resolved is that taxes are treated differently both in the Constitution and politically. And it's part of the structural check on government that it's harder to pass a tax. And so while you're right, I wouldn't let the government call something a tax that wasn't a tax in order to get the power to do something they couldn't do. Once they've said it's not a tax, I think they've ducked some of the political checks built into the Constitution and should be held to their word. That being said, that would require new law being made, more principled law. So one can, I guess, be disappointed that that Roberts didn't go there, but I suppose not horribly shocked or appalled that he looked at a bunch of lousy precedent and said, this isn't the time to be tossing out cases left and right. I got cases, I'm going to stick with them.
I agree with everything Eric just said, and it's, I mean, really what you had here was a sleight of hand and a game of chicken, both, right? I mean, on the one hand, they said, oh, we'll get this through. It's not a tax. It's not a tax. And this is what I pressed. We had this discussion when we had a debate, those of you here in the fall, when we had Larry Tribe and Richard Epstein, and Larry Tribe was pushing this tax point at a time when nobody else really was. And I said,
Roberts was a student of Lawrence Tribe's, I believe.
I think that's right. And I said, well, but isn't this really disingenuous? I mean, the procedures they used, the public messaging, everything they did, they were saying it wasn't a tax, and you're saying, but the flip side is, I mean, clearly the tax power, as it's been interpreted, is extremely broad. I mean, you can get taxed more or less depending on if you get married or have a child. I mean, the tax power is broad. The interstate commerce regulatory power is also broad, but not as broad as the tax power. So that's one. And then in the game of chicken, and where I think they really played chicken was by not adding a severability clause or constructing a severability clause that let the dominoes fall. The Congress and or the administration. So the administration, when they were challenging the individual mandate, they said, well, you can't just strike down the individual mandate. If you do, you've got to strike down the community rating and the guaranteed issue because it's going to fall apart. It's going to be way too expensive if you just strike down the individual mandate. And I think the justices, clearly the four dissenting justices here who agreed that it was unconstitutional but disagreed that it was a tax, the four conservatives other than Roberts, I mean, they said, well, then we just have to strike down the whole kit and caboodle, or at least this whole title of the law, because we're not going to pick and choose based on what you tell us now after the fact as a solicitor general making an argument for the administration. So they played a real game of chicken here. And so the sleight of the hand and the game of chicken in this case worked. And the real question is, in the long run, is it going to be better or worse from a legal perspective? And then, what's going to happen on the policy perspective? I think we're all in agreement that if the law isn't changed, it's going to be a disaster on the policy front.
So no consolation for you there. In the back row on the right, wait for the microphone, please. Yeah.
Two things. I take it you agree then that if, for example, Romney wins and gets 51 Republican votes in the Senate to overturn this, that therefore it would be underturned under reconciliation. I thought I heard you say that. I did, yeah. Okay, but my question is this. You've described a number of different ways in which the actual application of this law will be very disruptive economically. It can destroy markets, things like that. In your view, over the next 2 or 3 or 4 years, what are going to be the most obviously destructive aspects of the implementation of this law that are going to make the legislature, if anything will make them, realize how problematic it is in its implementation, and therefore the most likely points of pressure to make Congress look and see what it did in effect with this law and therefore make changes?
Well, I'm going to make that a quick answer for everybody here, starting with Paul.
Well, I think that the issue of the price tag of the law is going to be critical. One of the things the law does, and Avik alluded to this, is it also sets up different tiers of people. So the advantage you get for some low-income or relatively low-income people, you get more of an advantage from getting insurance on the exchanges than you will through your employer. So some of those people making up to $40,000 or $50,000 a year, some companies will say, well, we're going to drop some of our lower income employees into the exchanges, let them get the subsidies there. But that also sets up an unequal footing for other employees who get coverage through their employer, but don't get the benefit of that very generous premium tax credit. So the cost of the exchange, I think, is going to be one of the central issues. As more people are thrust into the exchanges, I expect costs to spiral out of control. And then I think, Medicaid is this ticking time bomb, both at the state level and for the federal government. I think the federal government alone is expected to spend, $700 billion over the next 10 years on the Medicaid expansion, assuming that it goes forward at any level like it was originally predicted. So I think the costs of the legislation are going to become very quickly apparent, assuming that the exchanges do get set up and people start flocking to them. I think very short order we're going to realize what the real price tag is.
Cost spiraling out of control. Avik.
I think by far the most important issue in the near term is the cost of insurance. 10 years ago, the average American spent 10% of his wages on health insurance. Today, it's 18%. That's just in 10 years. Obamacare is going to accelerate that trend. And one of the challenging things is that we don't see, we get a paycheck every month or every 2 weeks, but we don't necessarily get a statement that says this is how much you're paying for your health insurance, how much we're taking out of your paycheck to pay for your health insurance if you have employer-sponsored insurance. But that is going to be, I think, the most important thing to focus on, precisely because it's not transparent to most Americans, is to really talk about how much you're paying for health insurance and what that means in terms of the fact that your salary isn't going up, because all that growth in your salary is being used to pay for health insurance.
So the combination of economic doldrums plus rising insurance will become apparent.
Wage stagnation and or decreasing wages and increasing costs of health insurance.
Erik.
For me, I guess I'd say two things. One, it's similar to what they've just said. One, I think the cost of the federal government has been wildly underestimated. I think the cost of Medicaid to the federal government is going to just bloom. I think the cost underestimated. I think all these calculations were done in time frames that ended just before we actually kicked in the mandate and started all the costs kicking in. So that when you move the time frame down a window, the 10-year time frame starts doubling and tripling rather than being what they said at the first front end. It's ridiculous, actually, that the mandate doesn't happen till right at the end of it. But the thing that I think people haven't discussed yet, which we'll see how big a problem it is, this cost-shifting problem that they've been saying is horrendous, the cost of private insurance, is actually going to get worse under Obamacare, because by driving, 20 million people or 14 million people into Medicaid, Medicaid so wildly under-reimburses hospitals that if they're only getting 50% or 56%, I think is what I put in my brief for my docs, well, where do you think the rest of that's coming from? It's getting cost-shifted to private insurance, and that's just driving it all up. We did a calculation on this, and the answer is the mandate alone, forget the Medicaid eligibility, which is going to be horrible, but the mandate alone actually increased cost-shifting more than just leaving them uninsured and letting them go to the emergency room when they wanted to go, right? Because what happens is you get insurance, you start using healthcare more, and then the cost shifting kicks in more because your doctor's only getting compensated for half of it. So that's ultimately going to drive out hospitals, drive out insurance companies. I actually have this deep nagging suspicion that this was all some sort of terrible conspiracy to drive out private insurance so that we ultimately get to a single payer.
And Jim.
I agree with everything the other three said, but I want to add something to that. And the first thing is, as long as the cost thing, it's going to matter. But I think as long as the bond market holds on the U.S., and I think it will as long as we're a better bet than the EU and Japan, I think the most important thing that's going to drive this politically is when what happens, what Avik and JP were talking about. In other words, if you see employers in significant numbers dropping people's health coverage and pushing them into these exchanges, I think you're going to see a massive political backlash. The president went out and promised that this wouldn't happen.
If you like your health care, you can keep it.
We've got a paper that Paul's shop did by Richard Epstein and David Hyman that says we think it's going to happen. A lot of businesses are saying we think we might do it. If that happens, and now from a policy perspective, I mean, let me be clear. I think employer health insurance is a dumb idea, and it's a relic of the post-World War II era. And in fact, embedded within the Bush reforms and the McCain proposed reforms that were proposed and not acted on. It's not like the Republicans have done nothing. They were trying to move us away from this. But when the president goes out there and says, if you like your coverage, you can keep it, and you don't keep it, I think it's going to create the biggest backlash politically.
Got time for one more, I think. That was such a great last question. I'm almost tempted to end on it, but I'm going to go over here on the right here for one more.
In previous presentations, Richard Epstein has talked about cross-subsidies by the insurance companies. I've heard scattered news of Mitt Romney doing away with the restriction to buy insurance across state lines, which would really be a death blow to what each of the states have done in terms of cross-subsidy. Avik, perhaps you could comment on that since you're an advisor.
So is that part of replace the interstate insurance?
Yeah, and let me just say, since I know we have limited time here, but I'm happy to stay as long as anyone wants me to talk about the ramifications of all this.
You've been talking about it for about 12 hours already. Right?
Yeah, more than that. On this question of intrastate purchase of insurance, that is something that the Governor Romney has publicly stated he favors, and it has been a common strain in Republican reform plans for a long time. I would just caution you that the implementation and execution of that policy is a little bit more complicated than it sounds. It sounds great. Oh yeah, buy insurance from, the good people in, I don't know, Vermont, or maybe not Vermont, maybe, Utah, say, where insurance premiums are really low. But if you're an insurance company in Utah, you have to negotiate reimbursement rates for all those hospitals and doctors in New York if you're going to do business in New York. And large insurers like United and Aetna that have these state plans, they could probably bolt that in. But some more entrepreneurial insurers that are more regional in scope may not have the ability to do that, and it will take them time to build those networks, and they may not have the leverage because they don't have the market share in New York State, say, to say, a lot of what insurers try to do is say, look, you're not going to get my 20 million customers unless you accept my price. If you've only got 5 customers, the hospitals are going to laugh at you and say, we're going to charge you whatever we want, right? It's the economies of scale, market power, negotiating. So interstate insurance is a good thing, but you shouldn't expect it to magically, dramatically change anything. It's going to take time to build a national market for insurance. It'll probably take 5 to 10 years once a policy like that is ever even implemented.
Well, Avik said something earlier tonight, that those who want to replace this better start thinking hard about it. Our panel is comprised of people who are doing just that. We at the Institute are dedicated to doing just that. Thanks for joining us this evening.
I think it is clear how fortunate we are to believe in the power of ideas.
Supply the common sense and the fresh thinking of the Manhattan Institute.